much, Denise. So let's go right on ahead. Our first presenter is Mr. Richard Worsfold, who will be presenting Charitable Bequests, Pitfalls, and Best Practices. Richard brings over 30 years of litigation experience to Mills LLP as a litigation partner. Richard's practice includes a wide variety of complex matters, including will challenges, estate matters, shareholder right disputes, traffic fatality cases, incapacity issues, and wrongful dismissal claims. Richard concentrates his practice in estate litigation and commercial litigation. Richard takes on a practical and efficient approach to litigation, attempting to move disputes quickly to resolution. Richard is a firm believer in the mediation and negotiation process, but where settlement has not been possible, Richard has appeared in the Ontario courts at all levels. Richard is also a trained mediator and offers his services as a mediator to individuals and counsel in the Greater Toronto Area. Richard is an extremely successful litigator, and a quick Google search on Richard would present you with a list of significant cases of which he has produced successful outcomes for his clients. Richard, please take the floor. Thank you.
Thank you very much, Nate. That's very kind of you. And so Richard has all sorts of skills, but PowerPoint presentation is not one of them. So can you just tell me if I've actually got the presentation up on the screen?
Looks great.
I do. Great, thank you. So I just want to first thank you, Nate, and thank you all for being here again. As Nate was saying, this is our 6th not-for-profit Charities Get Together, our 2nd to be held on the Zoom platform. And I'm sure that while we all appreciate the convenience of the Zoom platform, I myself am very much looking forward to getting together, hopefully next year, where we can meet in person, enjoy some refreshments, and renew acquaintances live and in person. But as well, we can also learn a few things. And I'm here today to talk about charitable bequests, and in particular, the doctrine of sapere. I'm going to discuss problems that can occur in the execution and interpretation of wills, and to discuss potential remedies that may exist where gifts that a testator intends to give may be otherwise defeated by errors in language or failure in the will or trust document to properly express the wishes of the testator. At the conclusion of my discussion, I'm going to be covering best practices to avoid the need to invoke the doctrine of sapere, to avoid the need to talk to people like me about the interpretation of wills or trust documents. My overall message to you is that we need to communicate. Communication will hopefully prevent errors in drafting. It will prevent errors in language. It will prevent the necessity of asking the court exactly what the testator meant or how he or she wished his bequest to be handled. And by communication, I mean communication with your donors, of course, with your supporters, with those individuals who would be inclined to leave a gift to the charitable organization that you represent in their will or otherwise. And by communication, I mean all sorts of communication. Communication in your written material, be that your fundraising material, your correspondence, on your website. The website is particularly a key source of information for any drafting solicitor preparing a will or trust document. So the most common pitfall that occurs with respect to errors in expression is simply with the name of your organization. So be clear as to how your organization is to be referred to legally in all of your communications. As well, pitfalls occur when donors are confused about the actual objects of your organization or how.
Richard, sorry, Richard, to cut you off there, but advance your slides if you're going on ahead.
Yeah, I thank you for that, Nate. I'm actually not there yet. I'm not actually. I have a couple of slides, but I don't have a ton. So I think
no problem.
More slides than I have. Thanks for that. Yeah. So with respect to communication, the key, of course, is to allow your donors to understand how they can assist and to properly express the goals of their intention in their will so that they can be satisfactorily carried out by your organization. So now I'm going to advance my slide. The first slide is the introduction. And as you all know, testamentary giving can take many forms, but typically a gift is contained in a will or a trust document and consists either of an outright gift or the granting of an interest in the residue of an estate once the other obligations of an estate are dealt with. Typically, there should be no difficulty in interpreting the language of a will or how a gift is expressed, but that's not always the case. And as I say, the most common pitfall may be that the name of your organization is not properly identified because of an error or possibly a corporate reorganization since the drafting of the will. It may also be that a testator has contemplated a charitable purpose that is no longer applicable. Events may have overtaken his or her intention when they prepared the will. It may also be that what the testator or settlor contemplates is overly broad or impossible to be accomplished by your organization. In those situations where the wording is unclear or imprecise, an estate trustee will be reluctant to execute the will and may be reluctant to write a check to your organization, as he or she could be criticized by the other beneficiaries of the estate. You may be consulted by an estate trustee who is attempting to carry out the terms of a will, but is uncertain as to how to do that because they are not properly instructed by the actual wording of the will. The remedy, of course, is for you to consult with a lawyer and for the lawyer to consult with the court to obtain the comfort of a court order directing the estate trustee to pay the legacy or the residue to your organization where appropriate. So I'm going to go through some examples of where the court has been called upon to assist. But first, I wanted to outline some basic principles the court would use to guide themselves with respect to any question of interpretation. Here we go. First of all, the court will foremost attempt to give effect to the intentions of the testator, if those intentions can be properly determined by the document. The court will review the entirety of the will or trust document as a whole to attempt to determine the intention of the testator. And it may be that this exercise alone will permit the court to give directions as the intentions are clearly ascertained in the will. There may be situations, however, where the provisions of the will are impossible to be carried out on their plain meaning. The stated purpose may be impossible because of events overtaking after the preparation of the will, or where the expression of the testator's wishes is insufficient to understand what he or she is attempting to accomplish. Here, the court will, if there is an intention, an ascertainable charitable intention, invoke the doctrine of se pre. So what is se pre? Se pre is a Latin term which means as near as possible. It is an equitable remedy that's available to the court to preserve the charitable intentions of the testator to avoid the lapse or failure of a gift where possible. The key for the court is to determine whether or not there was a general charitable intent. Where it can be established that there was in fact a general charitable intent, but the actual direction wasn't possible to accomplish, the court can invoke its inherent authority to rectify and amend the terms of the bequest, to amend the terms of the will so as to effect the request as near as possible. So one of the best way to go through, try to explain how the doctrine of se pre may be invoked by the court is to take you through a few examples. And one of the best examples of a court invoking the doctrine of se pre is the case of the Weiniger and Canadian Diabetes Association decision. So in that case, the court was being asked to interpret a will which provided that the residue of the estate was to be provided to the Canadian Diabetic Association, and the direction was that the residue was to be used solely for the purpose of providing insulin to the needy. So the information before the court was that the testator's father had suffered from diabetes but had been too poor to purchase insulin. The information before the court was further that the name of the Canadian Diabetic Association had been changed. and was now known as the Canadian Diabetes Association. So that alone would be easy to cure. But the information before the court was further that the Canadian Diabetes Association did not provide direct healthcare services, and accordingly, it had no mechanism to actually distribute insulin to needy people. This was a case where the court found it was necessary to invoke the Sapri doctrine. The court reviewed the terms of the will, and it was clear that there was a general charitable intent, but the will was not possible to be executed as drafted because the Canadian Diabetes Association did not provide insulin to the needy, which was what the testator had directed. The court, however, determined that the Canadian Diabetes Association was clearly the intended recipient of the funds, and it invoked the doctrine of Sapri and directed that the Canadian Diabetes Association receive the funds and use them as closely as possible to the intended use, and that was to use the funds for ongoing insulin research. The court found the objects of the Canadian Diabetes Association were consistent with the charitable objects that were identified to be of value to the testator, and accordingly, the court was prepared to grant an order preserving the gift and avoiding the lapse or failure of the gift. So another example of the exercise of the court's discretion to save charitable bequests can be found in the Boy Scouts of Canada Provincial Council decision involving Doyle, who was one of the trustees of a trust that had been set up in the 1930s to hold a piece of land in Newfoundland called Trails End, and the direction of the trust was to hold that land for the first St. John's Troop of Boy Scouts for so long as that organization remained in existence. By the 1980s, however, the first St. John's Troop of Boy Scouts had ceased to exist, and the trustees of the land applied to court for a decision as to whether or not they should relinquish the land to the Crown as a result. The Boy Scouts of Canada intervened, and they asked the court to invoke the doctrine of Sapri. They asked the court to preserve the land for the Boy Scouts movement, notwithstanding the fact that the actual terms of the trust deed would require the land to be relinquished because the actual Boy Scout troop, which was to be the beneficiary of the trust, had been disbanded. So the court again reviewed the terms of the trust to determine whether or not there was a general charitable intention, and they found that that was so. They found that the doctrine of Sapri allowed them to preserve the intention of the trust by leaving the land to the Boy Scouts of Canada organization. The court noted that that any court should be hesitant to permit any gift to fail and should provide flexibility so that people with charitable intent may have their intentions met, even if situations change, provided that the overall intention of the testator can be determined by the will and it can be determined to have been a general charitable intent. So I'll just give you one or two other fascinating cases, and then I'll go back to the goal of how to stay out of court, how to stay away from individuals like me who have to argue whether or not there was a general charitable intent. You have the decision in the next case, which is, the Buchanan estate. So in the Buchanan estate, this was an interesting case involving a 1954 will, which provided that the entire estate was to go to the Loyal Protestant Home for Children in New Westminster, BC. But when the testator died in 1994, it was determined there never had been a Loyal Protestant Home for Children in New Westminster, BC. There had been an organization known as the Loyal Protestant Association, and there still was an organization known as the Loyal Protestant Association. But that organization did not operate a home for homeless children. It, in fact, had very diverse charitable objects, including the general benefit of society, and not just children, did not just involve themselves with the welfare of homeless children. The court found that the will, as drafted, did demonstrate a general charitable intent. And so although the will as drafted could not be fulfilled, the court permitted the Loyalist Protestant Association to provide a proposal to the court as to how they would use the funds in a manner that was consistent with the charitable intention to benefit homeless or impoverished children. As such, the gift was saved, notwithstanding the fact that the legal entity had never existed and the uses were no longer applicable. So one last case, which I'll refer to you because I found of interest. I believe there may be representatives from the from the Hospital for Sick Children here today, and this is a matter from 1974, which did involve the Hospital for Sick Children. In the Robbins estate, you had a situation where the court was dealing with a will that left the residue of the estate to the Crippled Children's Hospital of Toronto, Ontario. However, there was no entity known as the Crippled Children's Hospital, and there never had been. A number of organizations, including the Hospital for Sick Children, were notified of the application, and the court was presented, fortunately with a joint request in that case, by all of the organizations who might have qualified that the joint request was that the doctrine of SAPRI be invoked and the request be delivered to the Ontario Crippled Children's Centre, as it was then known, which was thought to best match the charitable intent of the donor. While not a hospital, the charitable intention was there and the Ontario Crippled Children's Centre was thought to be the best match. So I can go through many of the cases that have been determined under the doctrine of SAPRI, but I wanted to circle back to the issue of best practices. So while there is a saving provision in the courts will assist charitable organizations, they will assist testators to ensure that their charitable intentions are carried out. You don't want to go there. The best practice is to, of course, ensure that all prospective testators have a full understanding of your organization, in particular, a full understanding of the proper legal name of your organization and your objects. And again, it comes back to communication. Communicate with your donors, reach out to your donors, invite discussions with your donors with respect to their intentions and how they can assist your organization. Ensure that your website is clear with respect to these issues and discuss how you can assist in understanding how their funds are to be used so that when a lawyer is directed with respect to the drafting of a will, those instructions are clear, those instructions clearly identify your organization, and those instructions clearly, if it's the case, identify a use for the funds that is consistent with your organization's objects. So that's my presentation. I'll be around later to answer any questions, but be assured the courts are there available to assist, but you want to avoid that assistance if possible. So thanks.